Hello everyone, this is Vaishnavi and today I will be discussing on the topic of alternative dispute resolution under section 89 of CPC, its effectiveness and challenges. In India, civil litigation is often criticized for being lengthy, expensive, and adversarial. A dispute that begins as a simple civil suit may take years to reach final adjudication, causing mental, financial, and emotional strain on litigants. Recognizing this systematic problem, the legislature introduced Section 89 of CPC 1908, which marks a conscious shift from court centric justice to settlement oriented justice. Section 89 of CPC aims to ensure that not every civil dispute must necessarily end in a judgment, some can and should end in a settlement. Section 89 of CPC empowers the civil court itself to play an active role in settlement. The section states that when it appears to the court that there exists an element of settlement between the parties, the court shall first formulate the possible terms of settlement and second refer the parties to one of the recognized ADR mechanism. This means that court does not merely wait for parties to request ADR, the incentive comes from the court. Section 89 comes into operation after the pleading are completed and issues are framed. At this stage, the judges is in a position to understand the real dispute, assess whether compromise is possible, decide where litigation is the best route or not. If the court feels that the dispute is capable of settlement, it triggers Section 89. Section 89 expressly recognizes four forms of alternative dispute resolution: arbitration, conciliation, mediation, and judicial settlements, including Lok Adalat. Now, talking about arbitration, dispute is referred to an arbitrator governed by the Arbitration and Conciliation Act 1996. The arbitrator gives a binding decision suitable for commercial and contractual disputes. Second, conciliation. A neutral conciliator assists parties in reaching settlement. Settlement agreement has the status of an arbitral award, less formal and more flexible than arbitration. Judicial settlement that includes Lok Adalat, settlement facilitated by a judge or Lok Adalat governed by the Legal Services Authorities Act 1987. This award is final and binding and non appealable. Fourth, mediation. A neutral mediator facilitates communication between the parties. Mediator does not impose a decision, but the settlement is based entirely on the parties' consent, especially effective in family and relationship based disputes. Now, the question is what happens if ADR fails? If the dispute is not settled through ADR, Section 89 ensures that the matter is returned to the civil court and the suit continues from the same stage. No legal rights are lost, thus, Section 89 acts as a detour, not a dead end. Salem Advocate Bar Association versus Union of India, the Supreme Court upheld the validity of Section 89 and observed that courts must actively encourage ADR and procedural law should promote speedy justice. This case led to the framing of mediation rules and ADR rules across courts in India. Afcons Infrastructure Limited versus Cherian Varki Construction, this landmark judgment clarified the practical working of Section 89. The court held referral to the ADR is discretionary, not mandatory. Certain disputes are unsuitable for ADR, such as serious allegation of fraud, criminal offences, matters involving public rights. This judgment provided structured guidance to courts on applying Section 89 meaningfully. Now, talking about the effectiveness of Section 89 of CPC, first, reduction of judicial backlog. Section 89 helps courts divert settleable disputes away from lengthy trials, allowing judge to focus on complex cases. Second, speedy and affordable justice. ADR mechanism resolve disputes in months rather than years, significantly reducing costs. Third, a win win outcome. Unlike litigation, ADR promotes mutual satisfaction instead of one sided victory. Fourth, preservation of relationships, particularly useful in family disputes, business partnerships, and neighborhood conflicts. Despite its objectives, Section 89 faces several challenges in implementation. 1. Lack of awareness and acceptance. Many litigants and lawyers still prefer traditional litigation. Second, mechanical referrals by court. Some courts refer to matters to ADR without assessing suitability. Third, infrastructure and training gaps, shortage of training, trained mediators, dedicated ADR centers, and uniform procedures. Fourth, ambiguity in drafting. The wording of Section 89 initially created confusion, requiring judicial interpretation to clarify its scope. Section 89 of CPC is not merely a procedural provision, it is a philosophical shift in civil justice. It recognizes that justice is better served when disputes are resolved, not prolonged. However, Section 89 to achieve its potential, it requires judicial commitment, legal awareness, institutional strengthening, in conclusion, Section 89 of CPC transforms courts from dispute deciders into dispute resolvers.